Sources of law. There are four primary institutions that provide us with the law of the country: the Parliament, the courts, the European Union, and the European Council through European Convention on Human Rights. The Parliament and the courts are the national institutions, while European Union and European Council are community institutions. Parliament is made up of House of Commons and House of Lords. It is responsible for making laws, deciding taxes, and scrutinizing the government. The Parliament produces legislation in the form of statute law. In the UK, these are the highest form of laws. The statutes are not only inherently complex as they are open to interpretation, they are also becoming more and more difficult to understand due to the rise of modern economies. The Parliament also uses parent statutes to delegate the law-making power to ministers and other bodies and to facilitate the executive work. However, this poses some serious concerns because the secondary lawmaking is not scrutinized on the same level as the primary legislative power of the Parliament. But there is an ultra vires rule that allows judges to intervene if the ministers have gone too far with the power given to them. Note that the Parliament cannot restrict the legislative powers of a future Parliament. The courts apply these statutes to practical matters through interpretation, and they try to provide the correct interpretation of the statutes. Another reason courts are a source of law is that they have been developing law through the common law tradition for a very long time. This tradition has its unique features like precedent, case law reports, and case law decisions, etc. The highest court in the UK is the Supreme Court, formerly known as the House of Lords. A case can be brought to the criminal court if a person has committed a crime against the state, or it can be brought to a civil court if the dispute is between two individuals, for example, in the matters related to a contract. A reference can be made to the European Court of Justice by all levels of the courts. Wolf reforms have improved the working of the civil courts by expediting the process through case management and by giving the parties an opportunity to resolve their issues before the issue reaches the courts. This process is known as Alternative Dispute Resolution, or ADR. In common law countries where matters are not constitutional, the judiciary may also create law under the doctrine of precedent. The UK, Finland, and New Zealand assert the ideal of parliamentary sovereignty, whereby the unelected judiciary may not overturn laws passed by a democratic legislature. The third source of law is the European Union. The UK joined the EU in 1973. Therefore, it is of extreme importance to know about the EU legislation and its effect on the English legal system. European Union law is divided into primary and secondary legislation. The treaties are the primary legislation and are the basis or the ground rules for all EU action. The secondary legislations are in the form of regulations, directives, and decisions. They are derived from the principles and objectives set out in treaties. In the British constitutional arrangement, a treaty is only recognized in the national legal system if it was incorporated by an Act of Parliament. The European Communities Act 1972 gives effect to the EU's primary and secondary legislation in the UK. It is important to remember that future parliaments are not bound and can repeal this or any other act by an ordinary procedure. The Factors-Army cases have established that where there is a conflict between EU law and national law, the courts can disapply the national law. The fourth and final source of law is the European Conventions on Human Rights that is a part of the European Council. One important thing to note here is that European Council is not part of the European Union. The European Council and the European Convention on Human Rights were established after the Second World War to provide the protection to the rights. The European Convention on Human Rights has played an important role in the development and awareness of human rights in Europe. The development of a regional system of human rights protection operating across Europe can be seen as a direct response to the horrors of the Second World War and the threats of communism. The Convention established the European Court of Human Rights. Any person who feels his or her rights have been violated under the Convention by a state party can take a case to the European Court. The judgments of the European Court finding violations are binding on the states concerned, and they are obliged to execute them. The Labour Party introduced the Convention rights into the UK's legal system by passing the Human Rights Act 1998. The influence of the Act on the British legal system is huge and has sparked many debates and controversies. The Conservative government recently re-elected in 2015 plans to replace it with the British Bill of Rights. We will be looking at the Human Rights Act in the greater detail in public law lectures.